tax, interest and penalty equivalent to 10% of or rupees 10,000 whichever is higher due from such person and issue an order. So here in the section itself amount is mentioned, which is 10,000 or 10% of tax due, whichever is higher. This section doesn't refer to 122. 7311. It starts with non-option clause. It reads, notwithstanding anything contained in subsection 6 or 8, penalty under section 9 shall be payable where any amount of self-assessed tax or any amount collected as tax has not been paid within a period of 30 days from the due date of payment of tax. Again, here reference is made to 73.9 but not to 122, and 73.9 doesn't refer to 122. In contrast to 73.1, if we read 74, just now we have seen 73.1. In contrast, if you see 74.1, last three lines are somewhat different. And it says penalty equivalent to tax specified in the notice. So whatever penalty has been specified in notice, that will be levied. So rigmarole is happening. We have section 75.13, which says if any amount has been imposed as penalty under section 73 or 74, then no penalty for the same act or omission shall be imposed on the same person under any other provision of this act. So there will not be any double jeopardy. एक ही बार penalty लगेगा, thankfully. Then we have circular 171, which also speaks about 75.13 only. It reiterates what has been told in section 75.13. We have section 127, a unique provision. Here, powers are given to officer to independently invoke penalty proceedings. So if situation is not covered under 62, 63, 64, 73 or 74, 129 and or 130, then officer can invoke 127. And in section 128, powers has been given to waive penalty or late fee.
I think practically we have not seen cases of invoking of section 127 or the orders coming under directly 127. It generally comes through the assessment route which happens under section 73 and 74. But let us be mindful that even an order can directly come under section 127 which invokes penalty directly. Obviously there needs to be given an opportunity of being heard, but that's something which we should be mindful of.
So sir, that will happen post completion of 5 years. Right now they have 73 and 74 route, so they will not go to 127. But there will be situations where taxpayer has collected tax, he has not paid to the government, and 5-year period is already over. In that situation, department cannot invoke 73, cannot invoke 74. Then I am more than sure penalty order will follow under 127. So that is still there.
So so we come to a point that there is no time limit under which an order under section 127 can be issued vis-a-vis the time limit of 5 years or 3 years is specified under 73 and 74 respectively.
Yeah, so that seems to be a intention of legislature that, many times people collect tax, they don't pay. And they feel if this 5-year period is over, then they will not be required to pay tax. But intention of 127, read with section 76 is very clear. अगर पैसा कलेक्ट किया है in the name of government, you will have to pay back.
There is one more thing which I would like to touch upon when you talked about section 73, subsection 11. Now, it's an interesting section which, if you can go back to section. So, what section 73.11 talks about is that if the tax has been paid together with interest, but within 30 days of the time in which it was due. Now, what happens is that the tax liability on a particular transaction, let's say, was in March 2019. Now, again, what happens is that this has come to our notice after 2 years. So, the section itself says that if you have to claim the benefit of no penalty, then you should have paid the amount of tax together with interest within 30 days on which the tax was due, from the date of which the tax was due. So it was due on 30th April, let's assume. Now when we are sitting in after 2 years, can the reduced benefit, the reduced penalty amount benefit will be available to us or not? So there is a very recent circular by CBIC clarifying this, which I would like to you to clarify, okay, so that at least we all are aware of this provision.
So consider a practical situation. Many times, whether by choice or whether by chance, there is difference between tax liability declared in GSTR 1 and GSTR 3B. If liability is declared in GSTR 1, then department will definitely take a stand that it is self-assessed liability. You have on your own declared this liability in GSTR 1. And for some reason, some portion of that liability could not be paid in 3B. Now if we read section 73(11), it says, notwithstanding anything contained in 6 or 8, penalty under subsection 9 shall be payable where amount of self-assessed tax or any amount collected as tax has not been paid within 30 days from the due date. So due date is 20th of the next month, and within 30 days of that, if it has not been paid, will there be penalty? And penalty would be 10% of the such tax or 10,000. And it is very common. It happens. R1 3B mismatch is happening even today. So thankfully we have circular 76 from board. Now this circular is in a way solve this issue, but then it creates further issue. But let us cherish what board has given to us. So board says, for invoking 73(11), first of all 73(1) should be possible. And 73(1) is possible when amount is not paid or short paid. If amount is not paid or short paid, if you have already paid the tax before invoking 73(1), then 73(11) will not be invoked and you will be saved from 10% penalty. However, board further says, since there is a violation, octopus will come in and you will have to pay 25,000 penalty under CGST and SGST as a residual penalty. So in many situations, your residual penalty will be higher than normal tax payable. But then this is how it has been explained. Yeah, I think I am done with this.
So again, as we say, and as I started my discussion saying that when the penalty is moving from a discretionary to a mandatory penalty, now a question to Khushiram sir, that whether when we talk about penalty, can it be really waived? Because once we say that there is a section imposing penalty equivalent to the tax amount, and at the same time section 73 and 74 talks about some reduced penalty because of the factors which come into play, but is it really so? And what all factors can come into picture when we talk about reduction in the penalty? So your thoughts on that?
So Jignesh bhai has explained that we have two types of provision as far as levy of penalty is concerned. One is 10%, another is 100%. So 100, we on a normal parlance can say कि 100 को हम 10 तो कर सकते हैं, because we can argue there is no fraud, no willful statement, so at least it should come down to 90%. But that totally depend upon the nature of notice which has been issued by officer. If it is 73, then it is very easy to argue. If it is issued under 74, then it is very difficult. But there is one section 128 in GST which talks about power to waive penalty. But this power has been granted, or alternatively we can say is retained by a government to waive. So if we want to waive the penalty, there has to be some notification from the government for waiver of penal provisions on certain aspects of penal provision which has been provided under the law. Other aspect is which Madhavji was telling, ki penal provisions can be interpreted mandatorily or discretionary. When we were working under service tax regime or sales tax regime or excise regime, we always perceive the situation where we can very well argue and we can say that penal provisions cannot be either initiated or imposed on a automatic route manner. The department has to justify that I have done something which requires or which gives jurisdiction to the officer to initiate penal provisions against the SSE. But when we see GST law, section 73 or 74, it does not give that leverage. It says 10%, then 10% has to be paid. If it says 100%, then 100% has to be paid. Otherwise, we have to argue कि 100 नहीं हो सकता, 10 हो सकता है. Still, we were in the past era, we were having judgment of Supreme Court in the case of Hindustan Steel, which was very well used when service tax, sale tax, income tax, penal provisions were argued by councils. Ki penal provisions cannot be made mandatory. So as far as my interpretation of GST law is concerned, we can still argue on this front as far as 10% of the penalty is concerned. 100 to we know ki 100 ko 10 karne ke liye we have to justify ki we are not covered under section 74 notice or 74 notice. So penalty at best can be levied at 10%. Now question arises, what about balance 10%? So that particular provisions also has to be rationally interpreted or levied by the department when there is a bona fide belief. I can say this, Jignesh bhai will agree, कि I have paid tax on particular goods or service under a presumption of law that my supply of goods or supply of service falls under so and so category. But department says नहीं, मेरे हिसाब से तो ये इस कैटेगरी में इसमें होना चाहिए. So then you have to pay additional tax of 6% difference in rate of tax. So whether this particular difference is a bona fide belief or it is a what we say panel, what I can say is कि it will tantamount to willful evasion for 10%. कि नहीं आपने तो जानबूझ के ही किया है. If that is the case, then why a distinction has been made for levy of penalty for 10% and 100%? Why drafting a law and saying कि evasion नहीं है तो 10%, willful statement नहीं है तो 10%, otherwise 100%? That means department is itself accepting कि there is a bona fide. Otherwise, why they are waiving 90% itself? So when
but the question comes then why they are levying 10% also when there is a bona fide, then the penalty of 10% should also not come into
yeah, but unfortunately, Madhavji, the penal provisions has also to be interpreted strictly. We cannot put if and but in the penal provisions also. So what department will argue, there is a specified quantum of penalty which has to be levied if there is a difference in payment of tax by you and which is assessed by us. Rightly said, Jignesh bhai?
My mind says yes, heart says no, sir.
Very nice.
Sir, I partly agree with you and I partly disagree. So, sir, first of all, my understanding says 73, 74 provisions are borrowed from service tax regime. And let us run through those. I will briefly touch base those provisions.
for the same, I think the circular will help, wherein you have yourself self-assessed, paid the tax together with interest before the department comes to your gate and investigates, okay, that there has been a short payment. Until unless there is a short payment established. So if there is no short payment, proceedings under 73 cannot be initiated. And if it cannot be initiated, then without penalty, I think there is a clear escape route. Agree, Jignesh bhai?
Yeah, circular 76 will help you in that regard.
While it is binding on the department to follow circulars, but nevertheless, they may invoke penalties, but definitely we should have a good defense against those penalties which are levied against the RCs.
See, basic proposition is कि if we pay tax before department catches, then how can penalty be levied? Only question will arise कि what I have shown in my return and what I have paid in my DRC.
So, Khushiram ji, I will slightly disagree, and I will explain my disagreement.
Yes.
So, sir, I am referring to section 11AC. Provisions are parallel, 73, 74. If you see section 11AC, again I will touch base last two lines. Shall also be liable to pay penalty not exceeding 10% of the duty so determined, or rupees 5,000, whichever is lower. So for non-fraud cases in service tax regime, penalty was 5,000 or amount not exceeding 10%. Whereas in present regime, amount is fixed, 10,000 or 10%. So Act does not give any discretion to the officer. He may have sympathy for you, but he may have to go by Act. So my understanding says, my ex facie view says there cannot be any reduction, that 10,000 or 10% will be there. At least till tribunal level. Of course, high courts can give you benefit. Yes sir, Deepak sir, boliye.
Bombay Court judgment given under the VAT. Under VAT, audit was compulsory wherever, and then some similar fixed penalties were there. 0.1% of turnover.
Correct.
And accordingly, the officers had levied, and matter went to Bombay Court, and Bombay Court said no issue at all. Though the word is fixed, penalty has to be established, and penalty to levy or not to levy, or even it can be reduced. And they had reduced in that.
Yeah.
I forgot the name exactly, but there is on this aspect.
But Deepak sir, that will happen only at high court level. Till tribunal level,
Yeah,
because of wordings in the Act, I don't think we will have any benefit.
That's right.
And
However,
in fact, Jignesh bhai, I also want you to refer to section 126 and maybe discuss that. It is a section which refers to what should be the general discipline by the department to invoke a penalty. Now, while it has given a discipline, but I don't think so the discipline is followed or is being followed or will be followed. But so I would like you to elaborate that as well in the going forward discussion.
but before that, let me, since I have taken a view opposite to Khushiram sir, let me now take a view which supports sir's view.
Yes.
So, we have many judgments, even from high courts and supreme courts, which says if there are interpretational issues, if there is bona fide belief, if penalty is a revenue neutral situation, then there should not be any penalty. So definitely we can argue those cases. At what stage it will be accepted, whether board will come out with some circular, benevolent circular, it remains to be seen. In any case, penalty proceedings are quasi-judicial proceedings. So they cannot just levy penalty. It is quasi-judicial. But yes, at least at lower level, sir, expect penalty.
But here again I disagree with what you say. So there's a decision by of Supreme Court in case of Dharmendra Textile, which talks about that, and again it's an income tax decision which says that section 271(1)(c) penalty is a civil penalty. And when I go to my next question, was supposed to go whether the concept of mens rea, which is guilty mind, which is being argued by many of us, that for levying a penalty, it has to be established that there was mens rea and there was no bona fide, it was a bona fide belief. So whether that concept itself holds good under the GST law is something which again I would like you to answer.
Sir, first of all, I will again go back to 126 and then I will come to your
Sure.
question.
Sure.
Because you asked me two questions
Yes.
simultaneously.
Yes.
Okay. So, just to safeguard interest of taxpayer, section 126 has been introduced in the Act. It reads general discipline related to penalty. Subsection 1 says no officer under this Act shall impose any penalty for minor breaches of tax regulation or procedural requirement, and in particular any omission or mistake in document which is easily rectifiable and made without fraudulent intent or gross negligence. बहुत कुछ qualify कर दिया. So if you read this, you are required to fulfill so many conditions, then only you can take benefit of this section.
And minor breaches 5,000.
Minor breaches is 5,000, and otherwise procedural requirement of omission or mistake in document which should be easily rectifiable without intent to evade. So again, octopus type of situation, you can't escape from this. However, there is signing in this dark cloud. Subsection 2 is our best defense in penalty proceedings. Subsection 2 says penalty imposed in this Act, under this Act, shall depend on fact and circumstances of each case and shall be commensurate with the degree and severity of the breach. So as per this section, department cannot use same brush for all the assessee. Sir's case might be more genuine, my case might not be that genuineness, and there will be a different penalty in that situation. So 126.2, madam, just a minute. 126.2 gives some discretion to the department. Further, there is 126 subsection 5, where a person voluntarily discloses to an officer under this Act the circumstances of breach of tax law, regulation or procedural requirement prior to discovery of the breach by the officer under this Act. The proper officer may consider this as a mitigating factor when quantifying penalty for that person. So madam has raised one query, DRC 03. I think even circular and this section both will help you. Sir has also covered this. When taxpayer on his own, suo motu, paying tax and informing department, that can be one of the mitigating factor for levying penalty. However, if you see subsection 6, this section says, provision of this section shall not apply in such cases where penalty specified under the Act is either a fixed sum or expressed as a fixed percentage. यानी 125 में 126 में बहुत कुछ अच्छा है, but वो applicable नहीं होगा.
All door closed.
Huh?
All door closed.
All door closed. When I was reading 126, I was trying to find out whether this section has overriding impact over other penalty provisions. And to my surprise, there is none. Ideally, 126.1 should start with notwithstanding anything contained in any other provision of this Act. It is not there. A good officer will say, "ठीक है, this is general discipline. Consider me as an indisciplined guy, and now I'm levying penalty." What will happen? So, intention of legislature is again to protect taxpayer from penalty. There should be overriding impact here, which is missing. And worse is 126 subsection 6. And that's why we are saying penalty तो आएगा, SOCOS भी आएगी, penalty भी आएगा.
A nail in the coffin, the last one, which talks about that if it's fixed, nothing doing, it is to be fixed.
It is to be fixed. Now I will answer, sir, mens rea question.
Yes.
So we generally argue that there was no intent to defraud. It was a human error. Whether all these arguments holds goods nowadays. Before that, madam, you have raised your hand. So we always argue that intention was not to evade, it was a human error done by accountant. Whether all these arguments holds goods nowadays. Earlier, if you see trends earlier, I'm talking about 70s and 80s judgment. Courts have agreed that mens rea, without mens rea there cannot be any penalty. But if you see recent trend, courts are not agreeing this argument. Sir has referred to Dharmendra Textile Processor, 2012 judgment, 2008 judgment Supreme Court. Supreme Court very clearly said there is no need to examine mens rea for breach of civil obligation. And this is larger bench Supreme Court. There are good number of judgments from Supreme Court in case of Gujarat Travancore, R.S. Joshi. So friends, in commercial, this civil litigation, court is saying there is no need to get into mens rea. As far as criminal litigation is concerned, of course, you need to find out what was the motive. But here, even a small violation is good enough to invite penalty. And this is consistently being held by courts nowadays. Now, to what extent it is correct, whether this needs revision, Khushiram sir can definitely throw light.
And I remember one of the decisions wherein the court cited that this penalty is nothing but an extra tax which you are paying for non-compliance of the provision. So, equated penalty to a tax which is diverging from the basic principles of levying of penalty. So, Khushiram sir, your views.
So we can still argue for 10 and 90 fight as far as mens rea is concerned. Any views on this audience? कि mens rea अभी there is a fixed penalty under law. 10% is fixed. It is very difficult to get it reversed. But as far as 90 is concerned, can we still argue?
Sorry, just.
See, what we have to see nowadays is the specific provisions of law. There was a law earlier, before GST, that was interpreted on the basis of specific provisions. There were no specific provisions for levy of penalty, specific penalty, specified penalty, identified penalty. But under GST, 10% is specified, 100% is specified. We see 100% penalty in income tax also. We see 300% penalty in income tax also, but 300 is never being levied. Anyone faced in income tax 300% penalty? नहीं लगा है, 100 ही लगा है. But that 100 was also not specified to the extent that it was in relation to escapement of income. Now what we have to distinguish under direct and indirect taxes, that GST is a levy of tax at source, supply of goods and supply of service. So, as far as my interpretation is concerned, 10% मेंस रिया है या नहीं है, 10% is specified, but 10 और 90 के बीच में we can still argue कि मेंस रिया नहीं है. There may be willful statement. That may be a mistake also. Yes, sir. Yeah, but if department has issued 73 notice, see, what we are nowadays facing, notice is issued under section 73. What I have seen in last 6 to 7 months, state is issuing notice under section 73, center is issuing notice under section 74. Yes, and when we face the officer of a state, he says, अरे 74 का notice क्यों है, तो 73 का होना चाहिए. So he is arguing from our behalf. But can we say to central government कि भाई 74 नहीं 73 है? So what Jignesh bhai is saying is कि penal provisions has been specified under law. Mens rea was applicable prior to coming into force of GST law. There are plethora of judgments, everything. Now Dharmendra Textile and we have Reliance also, Reliance Petroleum, as far as income tax is concerned. These penal provisions under taxing statute is a civil in nature, we all know. It is just to compensate or deter or have a reformative or have a preventive to protect the interest of the revenue. कि भाई आप कुछ गलत करो मत, अगर आप कर रहे हो तो हम टैक्स तो लेंगे लेंगे, हम पेनल्टी भी लेंगे. पहले स्पेसिफाइड नहीं था, अब तो स्पेसिफाई कर दिया. सो नाउ इट इज वेरी डिफिकल्ट टू आर्ग्यू कि मेंस रिया नहीं है, आप मेरा 10% छोड़ो या 100% छोड़ो. एंड मोस्ट इंपॉर्टेंटली वी हैव टू शो आवर facts, circumstantial evidences, my bona fide belief, my intent while filing my return of income, my intent at the time of classification of service, my intent at the time of place of supply. All these we have to aggregate and put all these circumstantial evidence before the court or before the lower authorities to justify for claim of levy of less penalty, not zero penalty. हाँ जिग्नेश भाई.
There are few judgments now in GST where courts have not levied even 10,000 rupees for 10% penalty. There are judgments, but again it is courts have that power, and under 132, 136 they have their powers which they can utilize. But up to tribunal level, we have tough time now.
But
No, courts have discretionary power, sir. High courts have discretionary power to remove penalty. So, considering facts of the case and relying on 126 subsection 2, courts have given benefits to the taxpayer. There are n number of judgments even in case of detention penalties, where a token penalty of say 1,000 rupees or 500 rupees has been levied, and rest of the amount has been waived. That power court anyway has, and 126(2) gives them sufficient ammunition to invoke that power. But that will not happen at department level, that is for sure.
But again, to sum up, when we talk about mens rea, what I personally feel is that whenever we talk about those 21 offences or any other offence, that offence itself basically is constructed in such a way that if it is a fake invoice, there cannot be a bona fide intent to it. So I would say that different offences has to be looked at in different lenses, and then the bona fide has to be established to, so to say, claim any kind of benefit of lower penalty.
Yeah, so Jignesh sir has said that ki courts have waived certain penalties in recent times. So what I have discussed 2 minutes back is ki we have to present our case before the court ki whether there is a technical breach from us, there is a clerical error from us, or we have a divergent views, different courts have different views of interpretation. So then there has an inherent power before the court to exercise discretionary power to waive the penalty. But all these things will boil from to individual facts and circumstances of the case, on the basis of which the demand has been adjudicated against us, and under what circumstances penalty either has to be levied or has to be dropped.
So there has been a good debate on this topic, so we move forward. Now, a question to you, sir, that whether penalty can be levied even in cases of a non-registered person. So we have seen penalties levied against registered persons for filing returns, suppressing something or non-suppressing something, but can it be levied for a person which is non-registered or is not taken registration? Is that possible?
पहले तो ऑडियंस ये बताए पकड़ेंगे कैसे अनरजिस्टर्ड को? किसी ने कोई ऐसा सिचुएशन फेस किया है where department has cashed the unregistered person?
There's one hand, I think.
Yeah.
There's one hand, yes.
Difference in ITR and 26A is ITR and nil service GST return, or there is no GST return. Yeah. हाँ. तो वो तो एग्जाम भी हो सकता है सर्विस, गुड्स या सर्विस. इसमें
Right. So what she intends to say is that there are ways and means by which they can come to know that there was a person who was liable to pay taxes. So then in that case penalty will come? Or
Yeah, definitely it will come. Because if there is a evasion, then penalty offense has been done.
So I think taxable person is defined as a person who has taken registration and person who was liable to be registered.
Yeah.
And a penalty can be invoked against a taxable person.
And see, we have three parts in section 122. First talks about taxable person, second talks about registered person, and third talks about any other person.
Right.
So the department will link that also. Huh? See, that cannot be ground to escape our liability. Yeah, definitely.
You should have collected the tax and then
There is a evasion.
First of all, he is not collecting the tax, so the revenue is not deprived of any kind of amount. Okay, he is not taken registration, he is liable to be taxed, different matter. Otherwise, no ITC, nothing will be available against such bills.
the revenue has already lost the tax which should have been levied on that transaction.
How it is lost? He is not purchasing, he is purchasing, but he is not giving any, taking an ITC. He is selling, the other person cannot take an ITC. Where is the loss?
Sir, ITC is a benefit given to you. If you want, you avail, otherwise leave it.
Correct.
That ITC is a concession given to you.
Yeah,
It is your choice whether to avail that concession or surrender.
right?
But once supply has happened, levy has been attracted, you will have to pay tax.
No, who will
Section
pay?
9 is very clear on this.
No, who will pay? See, suppose the other person cannot avail any ITC, so this person is not collecting the any tax, I am telling.
Collecting tax
The
is
composition person is paying the tax. He is a 1% or something is paying the tax. He is a registered person. The composition person is a registered person. Unregistered person. I am talking about unregistered person.
Sir, let us look at from this perspective. That
Anyhow, say, is it debatable? I am not telling that
No,
he should not get a
I think,
registration. But prima facie, he is not a loss to the government.
no,
Until it takes the-
we at least we three of us disagree that this is
maybe
not
I-
a law. This is
I
not
have one.
enforcing my opinion.
I
Anyways,
have
I think the moot point, I think what you were trying to say is that even for an unregistered person, penalties can be invoked, and there are provisions of suo moto granting the registration, because department cannot levy penalty without registering a person. So to an unregistered person, there will be a suo moto registration given by the department, and then the penalty proceedings can be initiated.
Yeah, definitely.
We'll come to that. Sorry. Okay, please go ahead. We'll take the questions. Quick the
It's
questions.
not question, I'm explaining this
Sorry.
situation.
Yes, please.
So in our one of the case, the interception was done, the material was going to one of the client's branch which was not registered, which was in some other state. So they intercepted the vehicle, they detained the material, they created a temporary
Correct,
registration
correct.
and charged the penalty in
Correct.
that case. So
Exactly.
that way the things are happening.
Yes. So your question. Yes.
Yes, 126.3 is there.
Yes. So now a quick question to you, Jignesh bhai. When we talk about penalties, we have seen that for an offense there is a penalty. Now, assuming there is an activity, that activity leads to two offenses. Now, when we talk about, let's say, a person who was supposed to be registered, who is not registered, still without getting registration, he has issued the tax invoice. Now, there are two offenses in one single transaction, that he was supposed to take a registration, he has not taken it. One offense. The second is that he was not supposed to issue a tax invoice without getting himself registered. He has issued an invoice. Now, whether it is an incorrect or a false invoice or a bogus invoice, whatever you say, there are two offenses. How much penalty can be levied in such a situation?
So, sir, you are referring to offenses under section 122, subsection 1. There are 21 offenses and there are quite overlap. In many cases, one violation will be covered under more than one situation. Correct? Now, as I have said, there will not be any double jeopardy on this situation. Though this explanation is missing here, but we have to presume that this is already there, because there is a doctrine of double jeopardy. So, for one violation, there cannot be 2 times penalty. So, by that logic, there will be only one penalty.
Right.
However, explanation should be there, which is missing.
Right. Okay. it's a 122 penalty which will be levied. So, yes. So, coming to one of the very pertinent questions nowadays, which I face with many of my clients at least, that there was an invoice which was to be issued. Now, since the invoice was not issued, whether a penalty can be levied, whether a general penalty can be levied, or a penalty under 122 can be levied. So, this question comes very often. So, my question to you both, what are your views if an invoice was supposed to be issued and which was not issued, whether department can levy a penalty? And the next question in relation to that is, if there are 10 invoices issued without this, so whether there will be separate penalty for all those 10 invoices, or we can club it together to see that in a tax period or a bouquet of invoices is to subject to one penalty.
So, sir, you have asked me two questions. I will start with first, and if I'm correct, then you ask me another one.
Sure.
So, sir, you are referring to situation of 122 subsection 1, clause 1,
Right.
where a taxable person who supplies any goods or service or both without issue of any invoice, or issues an incorrect or false invoice with regard to any such supply. So, non-issuance of invoice is an offence. Even issuance of incorrect or false invoice is also an offence. Now, let me take you through Rule 48, Sub-Rule 5, which says every invoice issued by a person to whom Sub-Rule 4 applies, means to whom e-invoicing provisions applies, in any manner other than manner specified in Sub-Rule shall not be treated as an invoice. So, if I am supposed to generate an e-invoice and for some reason I have issued physical invoice, then it is not an invoice. So, now question arises, is it a incorrect invoice? Is it a false invoice? Or is it a defective invoice? If it is incorrect or false, then of course 122(1) subclause 1 can be made applicable. But if we argue that it is a defective invoice, and if its defect can be cured, then we can definitely come out of this clause. As of now, my understanding says we are allowed to even do backdating of e-invoicing. Correct? So, up to 30 days, yes. So, within that time period, I can cure this defect, and I will take a view certainly that it is a defective invoice which got cured subsequently, and that's why I am out of this section. However, if that 30 days window is over, then we may have tough time.
Got it. Thank you. Now, as we all know, provisions of penalty. One more question. I think the sub question was left out. The question was if there are multiple invoices for which the invoicing is not complied with, what kind of penalty? Whether it's a general penalty of a composite 25,000 per tax period, or 25,000 per invoice, or whatever may be the provisions. If you want to explain that, please.
Sir, I vaguely remember there is a judgment on this, and it is against taxpayer. It says penalty will be applicable for each instance of default. This was, I understand, might be Kerala High Court judgment, and it has gone against taxpayer. So if courts take such a view, then assume a situation you have 10 invoices, you may be required to pay penalty in respect of all 10 invoices.
Okay, that's interesting actually.
But there is a judgment.
Yeah.
So again, sir, civil versus criminal will come in. It is easy to commit crime and you can take bail, but it is difficult nowadays. It is very much difficult to take a bail in GST evasion cases. Actually, it is happening like this.
Now, a question to you, Khushiram sir, that while we have discussed and covered this, an express answer to a question: if an audit commences, and before audit on our own violation we are paying the taxes, okay, in that case, are there any chances of penalty? While we have answered this, but maybe a affirmative view, what you believe.
What we have discussed in some time back, a question was raised by a person in this sitting last row, that if we pay tax before department catches us. So now question arises, if we pay tax under DRC 3, which Jignesh Bhai has said, then there is no penalty. But if department issues DRC 1,
Yes.
then you have to pay penalty.
So that means even, let's say, an ASMT 10 issued,
Yeah.
just asking a difference of, explaining the difference between 1 and 3B and a consequence demand which is raised,
Yeah.
then you are caught.
Yeah.
Because even after that, even though the violation is not expressly said, but because that period is covered
Yes.
in that kind of amount, or the transaction is there in that period,
Yeah.
then you are left with no option rather than to pay the penalty
Yeah.
to the express provisions of Section 70.
Yeah. So when we are submitting our documents before the audit party, and we ourselves come across with the situation that this particular document will create a nuisance for us and will create a liability against us, then it is very clear and good for us to pay the tax through DRC 3 instead of giving department chance to issue DRC 1. Correct, Jignesh Bhai?
So, sir, your question was if in response to ASMT 10, if I am making tax payment, am I required to pay penalty? Is that your question?
Yes.
So, sir, unless SOCOS notice has been issued, ASMT 10 or DRC 1A is not a SOCOS. It is a stage prior to SOCOS.
Correct.
And if I am paying tax before issuance of SOCOS notice, then of course there cannot be any penalty.
Correct.
However, particularly central audit team, CGST audit team, if you are making any tax payment post issuance of ADT 1, that is notice for conducting tax audit, then they are taking view that this audit notice has prompted you to make the tax payment, and therefore you are required to pay penalty. That is what the view they are taking. I am not endorsing that view. As long as SOCOS notice has not been issued, 73 76 benefits can be extended to us.
Correct.
Department may not agree, that is their problem. But certainly, there will not be any penalty as long as we are paying suo motu voluntarily.
And Madhavji, in one of our cases, we have paid tax in DRC 3 after issuance of ADT 1. So, as far as my interpretation is concerned, we can still avoid penalty
Correct.
by complying under DRC 3.
Okay. Next question to you, Jignesh Bhai. When we talk about wrong availment of ITC and its reversal, while there is a clarificatory amendment which has come in Section 50, which talks about that interest is not applicable until unless credit is wrongly utilized and not only availed, whether the similar kind of interpretation can be taken in for penalty as well, where even though credit is not utilized, whether it will still tantamount to levy of penalty, or there is some other reading which we can take out.
So now, as far as interest is concerned, law has been amended. If credit has been wrongly availed but not utilized, then there is no question of interest. What will happen if there is for penalty? Can we take same stand? Do we have some definitive argument for this? Any judgment for this? Because if you read 73(1), it says wrongful availment or wrongful utilization of ITC. So officer will throw this section at your face and say, sir, you have wrongfully availed or utilized ITC, therefore there will be a penalty in your case. However, thankfully there are few judgments now. In fact, there are three. The first one was in the case of commercial steel engineering, Patna High Court, where transitional credit was wrongly availed but not utilized. Issue arose whether penalty will be applicable. And Patna High Court very clearly said that that should be a positive action on the part of taxpayer. Mere claiming tran credit does not amount to any loss to government. So that judgment was already there. It was 2019 judgment, pre-COVID era. Recently, this judgment was followed in the case of Athi Hotel, Madras High Court. Madras High Court has taken a view that credit was availed, but it was also reversed. Therefore, there is no question of penalty as such. However, court took a view that since there was an attempt to avail ITC, there are good chance you might have utilized in future also, and that's why token penalty of 10,000 was levied. However, we have one more contradicting judgment from Punjab and Haryana High Court, recent one. In this case, there was a issue of interest as well as penalty. Interest now we very well know it is settled. But in case of penalty, court held that demand of interest and penalty is not tenable when credit erroneously availed is reversed and such credit is not utilized by the SSC. Here even a token penalty of 10,000 was not levied. So in a previous judgment of Athi Hotel, Madras High Court has levied token penalty, even though there was no utilization, whereas in this judgment, even that token penalty was waived. And that's what Deepak sir, powers of court, they have got every right to waive the penalty.
Exactly. This is strictly against what has been expressly provided, and if you literally read section 122, it talks about availment or utilization. It does not talk about availment and utilization. So it effectively means court is going beyond what has been expressly stated in the law and basically striking down the penalty.
No, sir. Under 73 and 74, even if there is wrong utilization, wrong availment, they have power to issue show cause notice.
Right.
We cannot challenge that power. But whether penalty can be imposed, answer is no. Penalty cannot be imposed. They can very well investigate the matter.
Right.
So that way it's a very good judgment.
Yes. Now I think we are left with I think 15 minutes or so, and I believe prosecution is something which we still want to a little bit discuss. While prosecution itself as a topic again can take a lot of time, but coming to the instances of prosecution being very limited and only restricted to certain specific situation, we'll touch base upon certain specific aspects of prosecution from a court point of view, because whether it is bailable or cognizable offense, okay, in what cases it can be invoked, and it's generally subject matter of taken to the writ courts and other cases. So Khushiram sir, for you, what are the safeguards one can take in a prosecution, any kind of CBIC guidelines for prosecution, and what are the provisions of prosecution? If you can just touch base on that, that will be helpful. Sure, that will be great.
Have you all understood the panel provisions, offences and penalties? Basic proposition for prosecution is demand against the SSC. Rightly or not? For invocation of prosecution proceeding, there has to be a difference of demand which I have declared and which department has assessed. First point. And second is penal provisions. Earlier, before GST, penalty was not automatic. So we tend to argue that prosecution cannot come into play unless penalty is levied and penalty is accepted by the SSC. So the starting point for prosecution was, if I accept the payment of penalty, then I am accepting mens rea, I am accepting willful default, I am accepting fraud, and therefore prosecution has to be launched. This is the starting point of prosecution. But from last 5-6 years, I have seen cases that before issuance of any order of adjudication order, penalty order, there is a direct launch of prosecution. अभी भी होता है practically. If we face anti-evasion unit, they issue summon, and client has a fear कि इस summon में respond करे या नहीं करे. because there is a apprehension. He knows what is the guilt. If there is no guilt, he will definitely face the situation. He will say, मैंने कुछ गलत किया नहीं है, आने दो someone, I will attend. But there are certain circumstances where there is a fear कि someone issue हुआ है, there is a chance of arrest. And prosecution is very draconian provision. It will spoil the image without any default. So, if we see section 69 and 132, these two sections are interlinked as far as prosecution is concerned. 69 talks about jurisdiction, assumption of jurisdiction by the officer under GST to launch prosecution and to continue the prosecution proceeding. 132 talks about what are the circumstances under which prosecution can be launched. Now one question arises, very, very interesting question is, कि when we link section 132 with 122 and we see Roman number A with Roman number 1, there is a clear-cut distinction between what are the offences in which prosecution can be launched, in which prosecution cannot be launched. So what is the guiding factor? The guiding factor is that we have to see what kind of offence which has been alleged by the department against us, whether it falls under section 132 or not. If it is falling under section 132, then question arises, who has the power to issue arrest warrant against the SEC? Now section 69 clearly says, Commissioner of GST has power. In case of cognizable and non-bailable offence, Commissioner has power. In case of non-cognizable bailable warrant, Deputy Commissioner, Assistant Commissioner has power to invoke arrest warrant. Now recently there was a Gujarat High Court decision which is very good judgment, and this judgment has been very well cited by the institute in its books. The books has been published which talks about significant ruling under GST, which covers both high courts and advanced ruling also. And I would like to read certain points from that particular judgment which will throw light how court has seen as far as prosecution proceedings which has been lost by department, what are the flaw which has been done by department. It is the case of Vimal Goswami. Dispute was whether provisions of CRPC, section 154, 155, 172 can be made applicable for assumption of jurisdiction under section 69 by the Commissioner of GST. Second was whether section 69(3), the Commissioner has power in consonance with the power of police officer who is in charge of police station. Third is the constitutional safeguard to any SSC for contesting the allegation of prosecution, allegation of willful evasion of tax, willful misstatement, etc. That Gujarat High Court has cited D.K. Basu case, which is very good judgment, and it is very fortunate that Gujarat High Court has cited that decision, because that judgment deals with what are the basic safeguard which has to be taken by department before invoking prosecution proceeding, because it spoils the reputation and image of the SSC. So what legal proposition has been laid down is there has to be subjective satisfaction by the Commissioner. There should be some credible material against the SSC for launch of prosecution and continuation of prosecution proceeding. The power conferred under GST authorities under section 69 for arrest could be termed as very drastic and far-reaching power. So therefore, since section 69 may have an irreversible detrimental effect on the business of the SSE, therefore the powers of section 69 has to be exercised by the officer with due care and should be used sparingly and only on substantive vague grounds and reasons. So if we read this judgment and understand the prosecution proceeding, first question, the last sentence of this judgment is that there has to be demand against the SSE.
Correct.
So when there is no demand, what is the question of launch of prosecution and continuing of prosecution proceeding?
And demand has to be confirmed.
Yes, it should be undisputed demand. If I am disputing that demand, then until and unless that particular demand is quantified against me or which has been accepted by me, till that time prosecution should not be launched.
We don't need it.
So basic proposition is adjudication order. After adjudication order, there should be penalty order. Because prosecution without penalty also is not a good law. Simply non-payment of tax could not give jurisdiction to any officer for levy of launch of prosecution proceedings. Because department and court itself says penalty provisions under direct and indirect tax are civil in nature. So if penal provisions are civil in nature, then the questions boils down to mens rea. If I have done something with culpable mental state of mind, then only prosecution can be launched and it can be continued. Otherwise not. This is the summary of Madhavji as far as prosecution law is concerned.
So, and this is rightly so. In the same spirit, CBIC has come with a circular which clarifies certain basics of prosecution with the sole intent that the powers are not overused or abused by the department. Now, it simply says that prosecution, just because there is a demand, now it goes to say that just because there is a demand, it cannot be said that there is a prosecution which is applicable. The second statement is that if a particular dispute is a technical in nature or where the claim is based on interpretation of law, prosecution cannot be launched. Just because there is a interpretational nature, obviously the SSE has all rights to contend it in the court of law and therefore prosecution cannot be launched. Now, also the prosecution can only be launched in cases where the offense is major in nature. It cannot be for some trivial offenses, prosecution cannot be launched. Now, again, and with the sole intent of giving some benefits to the industry, they have also basically decriminalized certain offenses in the very recent budget. They have said that and also increased the thresholds for launch of prosecution and kind of offenses. So what we are looking at and what we are seeing as a trend is that the kind of offenses or the prosecution, the way it was envisaged at the time of putting it up in the GST law is going drastically, it's changing, okay, it's getting mellowed down, but obviously to an extent possible, because ultimately the intent is still to comply or to ensure that the SSEs are compliant with the law. So with this, I think we are done with today's session. I request you to ask any of the questions if you have. We have 10 minutes or 5 minutes with us. I would request if you would like to ask any question, happy to answer that. Yes. 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 There's no penalty. 73.5 or 73.8. Yes. So if it is within 30 days, you pay from the show cause notice, there is no penalty. Correct.
Provided SOCOS is under 73.
Yes.
Center never issues SOCOS under 73. Center team, they issue SOCOS under 74 only. There is nothing like 73 in the textbook.
Now, any practical instances to share, because what I have seen personally is that while there is a penalty in a show cause notice which we face, but we generally don't respond so particularly to a penalty invoking, rather, because what we only talk about is that the tax is not payable. But any practical instances which you would like to share if you don't have quick questions? Yes. Without? Without DIN. Okay. Yeah. DIN. In my view, can be challenged.
So we have a recent judgment from Supreme Court in income tax matter which very clearly says that it is irregularity, but that will not make notice invalid. It is last week judgment. So if CA, by in same logic, CA can also sign audit report without UDIN, it is irregularity, but that will not make audit irregular. Everything has been quoted, but whatever finance minister says has got no value. You know it very well. There are judgment which says whatever finance minister has said in the house of in the parliament has no relevance as far as interpretation of tax is concerned. So fine. If there is nothing, we can discuss few things more. If there is nothing, we can discuss. Otherwise,
I think there is one question. Yeah, please. Good.
you should be more than happy then to challenge such SOCOS.
Yes.
Yeah, but then this. So, gentlemen, we have very good judgment on this.
Yeah.
We have very good judgment on these issues. In fact, Jharkhand High Court has given many judgment on this. That if irrelevant portion is not scored out,
Yes.
then it is not a good. It is not a SOCOS itself.
Correct.
It is not
Very
SOCOS.
specific.
So it is Juhu Industries. It is. We have 2-3 judgments from Jharkhand High Court on this. One was Juhu Industry. One was 2-3. That is there. But if such judgments were not there, then we don't have any defense only.
Yes, please.
We have discussed this in circular.
We have discussed this.
Circular 76 you may refer.
Circular provides a defense. Yes.
Of course, yes.
Yes.
Of course, yes. If you see Rule 36 lists down various documents on the basis of which you can claim ITC.
Correct. If we read strictly, I think on a bill of entry, you can take a credit and there should
16.4
not be a
talks
time
about
limit.
any invoice or debit note. It doesn't talk about bill of entry.
Bill of entry.
Yeah, that is
Yeah,
fine.
that's what I'm saying.
That is fine.
That's what we are saying, that the time limit should not apply to cases of bill of entry. Yes. Yeah. Yes. I think you have already covered it, but we can.
even there are judgment which says if there is a dispute as to classification, there cannot be any penalty.
Correct.
There are judgments even in GST regime. Fine. So again, we will have to go to court. So we have covered, sir, Circular 76.
So I think we stop here. Maybe if any questions, we happy to discuss on a person-to-person basis. That will be better in the interest of time of all. Thank you so much from our side for a patience listening. And,
So on behalf of WIRC, I take this honor to present the vote of thanks to our eminent panelists, CA Khushiram Dhahdwani sir and CA Jignesh Kansara sir, who have generously shared their insights and expertise on penalty and prosecution provisions. And thank you, Madhav Kalani, for structuring exclusive questions for the session. Thank you so much for being patient audience and such an interactive audience. And we look forward to you for tomorrow's session as well. Thank you so much. Sir, ये laptop किसका है?
Check.
माइक ले ले पूरा। हाँ हाँ।